Welcome to Plead the Facts, presented by KI Legal. On today's episode, Socrates Xanthopoulos, partner at KI Legal, is joined by Michael Iakovou, co-founder of KI Legal, to discuss what to keep in mind when buying a business in New York. Hi everybody, welcome to Plead the Facts, hosted by KI Legal. I'm here today with my partner Mike Iakovou, and we're here to talk about how to go about buying a business in New York.
Congratulations, you're taking the plunge.
It's a very exciting time when one is looking to buy a business, especially for first-time buyers, just like it is for a first-time home buyer. But there are significant risks and pitfalls that need to be taken into consideration, especially if you're not a seasoned vet that buys and sells businesses, over the course of the years. And for that reason, it's imperative to have an attorney by your side to essentially hold your hand throughout the process and ensure that you're protected.
Let me just rephrase that real quick. Not just any attorney, but an experienced commercial transaction attorney, one that is actually handling deals either on the buy or sales side. It could be in conjunction with underlying real estate. They may be handling both. But it's super important that you're not going to your quote-unquote personal injury lawyer to handle your commercial acquisition, your M&A deal, or even if you're just buying a small business. There are many nuances to the space, to that area of law, tax considerations, liabilities, as you said. That if you do not do this on a day in, day out basis as a transactional attorney, you simply you can't just go off of a checklist or look this stuff up on Westlaw. You have to kind of know what you're doing.
So you mean the attorney that I hired to get me off that DUI case?
Probably not the best idea, no.
Okay. No. All right, good to know. So what are the things that you should look out for when you're looking to buy a business, and what does the process itself entail?
Well, look, first things first, I think if you're going with a broker, similarly to real estate, there are business brokers who should be utilized to the extent a good one. And just like lawyers, there are good brokers and there are bad brokers. If you have a good one, work with him or her very closely. They're going to be able to kind of parcel through the quote-unquote crappy businesses and the ones that you should really look at. If you have one and they do present a short list of good businesses to consider, you're going to go and you're going to do a site visit. You're going to try to you're going to want to be quiet so not to let the customers know that you may be looking to buy the business. The same way you'd be looking at like a multifamily apartment building. Don't let the tenants know that you're there. And then assuming that you reach a deal with a deal in principle with the seller, you're going to enter into what's known as a letter of intent, or the negotiations up until the letter of intent. Why don't you walk us through that a little bit?
So the letter of intent, LOI, term sheet, deal sheet, goes by different names. It generally sets forth a roadmap for the key terms of the deal. It's not the formal, full-blown purchase and sale agreement. So it's more high-level bullet points setting forth purchase price, party names, any conditions and contingencies, perhaps how the deal itself is structured, asset purchase as opposed to a stock sale. It could set forth, it'll include the attorney information. So that's why when you're ready to strike the deal, you want to have an attorney already lined up, an experienced one like Michael said. But the key thing to consider when it comes to LOIs is that you would ensure that there is language in the LOI that makes it not binding. The last thing you want is for you to have a change of heart after you informally come to terms with the seller, and only to then be faced with a lawsuit for breaching the terms of that quote unquote agreement as set forth in the LOI. In most cases, it's typically held to be not binding, but courts have ruled under certain circumstances in particular cases that an LOI is binding, and parties have suffered the consequences as a result. Had they had an attorney to review the LOI at the time that it was negotiated, prior to signing it, that attorney, assuming that they were a good and experienced one, would have ensured that that wasn't the case.
And one thing that you do want to do in conjunction with negotiating the LOI, specific to businesses that you're buying that have a strong licensing component to them, is do your due diligence on those licenses. So if you're buying a nightclub or a bar, for example, you want to make sure that if you are that liquor license, if that liquor license is going to be assigned to you, that you are a person of good moral character, that you'd be able to actually be assigned that liquor license. So you should consult a liquor license attorney, right? If you are a pharmacist looking to buy a pharmacy, there are two ways of going about it. You can have the underlying pharmaceutical licenses, pharmacy licenses, in conjunction with the insurance companies, be assigned over to you upon closing of the deal, or you can go and enroll in new licenses with insurance companies. The second one really doesn't happen that much anymore, just because of timing issues, and now it makes things a lot more difficult. Not to say that it doesn't happen; it's mostly more of assignments. But again, you want to make sure that those things can actually happen. So it does add a little bit of more of a wrinkle to the deal. So again, due diligence is key. You're gonna spend a lot of time and money on your due diligence and your LOI, and to the extent that you do, it's gonna save you a lot of time, money, and potential heartache later on when you get to the contract phase.
Of course, if you are a licensed professional yourself looking to buy into a particular practice, make sure that your license is in good standing. It could be a medical practice, it could be a law practice, buying a law firm or into a law firm. All that stuff is extremely relevant, because at the end of the day, if you buy the business, you shell out all that money, especially if you're financing your purchase, and ultimately you aren't appropriately licensed and don't have all the right certifications in place, you will ultimately see your dream unwound. And of course, you don't want that to happen.
These are the top 10 things you need to consider when doing your due diligence when buying a business. Number 1, review customer information, operational processes, and goodwill of the business. Number 2, review the employee base and retention. Number 3, review the bank statements, debt and financial statements, and tax returns. Number 4, review all employee contracts and non-compete agreements. Number 5, review all business licenses.
Now, after you review the business licenses, you want to make sure that, number 6, they're transferable. Can you assign them? Number 7, you want to review real estate agreements, commercial lease agreements, service contracts, vendor agreements, and other client account agreements and the like. Number 8, inventory lists and asset schedules. Number 9, lien, judgment, bankruptcy searches, pending litigation searches. And finally, number 10, corporate and organizational documents of the seller.
You review all 10 of those things, you should be in pretty good shape to decide whether or not you want to go forward with the deal.
So when you're looking to buy a business in New York, what exactly are you buying? A business is, in some sense, intangible, right? But legally speaking, when we're papering the transaction, you're typically either buying the assets of a business, or you're buying the shares of stock of, if it's a corporation, or the membership interests if it's an LLC. And there are great differences between the two types of transactions, and I'm going to let Michael kind of give you the introduction on that.
Yeah, so look, ideally, if you are a buyer, you really want to limit in risk and exposure, so an asset purchase sale is preferable for most transactions, because if you're buying the assets, meaning the cup, this microphone, this pen, and not all the liability and everything else that comes with this cup, this microphone, etc., that's a pretty good way of going about the deal. Now, that's not always the case. Before we discussed specific businesses like pharmacies, for example, or restaurants and nightclubs. With with businesses that are subject to licenses that are hard to get, it may make more sense, assuming again you do very, very proper due diligence and you're able to walk into what I tell all my clients, into the deal eyes wide open, assuming you can go into the deal, you've uncovered, there's no surprises, you can go into the deal and you've uncovered all of the booby traps, and there are none. Then you could potentially go forward with a stock purchase, because inherent with all the goods with a stock purchase also come all the bads,
Correct.
all the liabilities, all of the potential wage and hour lawsuits, all of the potential negligence lawsuits, tax lawsuits, audits, anything and everything under the sun. And it's very important that going back to that LOI stage, the diligence stage that we discussed before, that you have competent representation both on the tax side and on the legal side, so that, again, you go in eyes wide open.
Correct. So on a stock sale, which is the structure that's preferred by sellers, sellers want to get their money at the closing table and walk away, don't have to do anything with the business again, no trailing liabilities. And essentially the stock sale allows them to do that because the buyer is acquiring everything that they see about the business, good and the bad, like Michael said, assets and liabilities. Whereas on an asset purchase, preferable for buyers, you get to cherry pick which specific assets you're buying and which specific liabilities, if any, that you are taking on from the existing business. And that's especially important in the context of, for example, employment law and wage and hour cases. If you're buying a business that has employees, of course. Do you want to explain why, Mike?
Yeah, so there's something called successor liability, and in the employment context, for unpaid wages, underpaid wages, it's something that we do and see a lot here at the firm. States like New York have made it very difficult for small businesses to exist, but also to be sold and to be bought. There are look-back periods, statute of limitations going back many years, and you have employees that worked at your establishment for a week, and they have a certain number of years to commence an action. They can be part of something called a class action, right? A class. And opt into a class action lawsuit and hit you with a variety of different lawsuits, both at the federal and at the state level. And it's important that, you know, when you are purchasing a business, that you try to box out all that exposure. Now, going back to the asset purchase scenario, even in that case, right, it's not foolproof. So we do an asset purchase sale, you think, okay, I'm not buying the stock of SOC LLC, right, or SOC Corp. My Corp is a new entity, therefore I'm good, right? Well, maybe not. My Corp starts a new business on day 2. SOC Corp was around on day 1, but My Corp kept all of SOC Corp's employees. I never fired them. I just kept them on. I say, guys, I'll see you tomorrow. I'm the new boss. But I kept paying them the same way. There was nothing changed. So now we got this big problem. It becomes a question of fact, right? And before you know it, some of the employees aren't happy. Maybe there's a lawsuit related to unpaid wages, and now everybody's pulled in. Mike, SOC, and we're both counterclaims against each other, and it's a huge mess. So it's very important that when you're drafting your PSA, which is your purchase and sale agreement, that there is delineating language as it relates to indemnification, meaning who's at fault, and there's almost like a timestamp, right? There's a bright line as it relates to date and who is responsible for actions after this date and who's responsible for actions before this date. If you can get that in the agreement, and again, the litigation often, yes, it relates to the facts and what the conduct of the parties, but it often lives and dies based on the four corners of the document and how good the transactional attorney was that was drafting said document. Right, Sock?
100%
Couldn't have said any better, right?
That's where the master craftsman comes into play and really sets him or herself apart from, you know, the attorney that doesn't do this stuff day in and day out. And, you know, we've had clients in the past that have come to us to handle litigation for them where they're sued personally, in their personal capacity, even though they own the business in the form of an entity. You know, my entity employs the employees. Why am I being sued? Why would I be liable, you know, for that? Especially when it was the former owner, the person that I bought the business from. What we're being sued for is something that they did. Well, there's personal liability for the top 10 shareholders of a closely held corporation under the laws of the state of New York. And you can't escape that. So that's why it's extremely important to ensure, like Michael said, to the extent that there are any claims that are brought against you or your business after closing, who's going to be responsible for that? Now, you may get sued, you may ultimately be found liable, but if it's for conduct and actions or omissions prior to the date of the closing, you want to ensure that the seller is going to indemnify you. So even though you're found liable by the court of law, you can go after the seller because it was because of him that the claim came up in the first place.
Yeah, so we touched on wage and hour considerations, negligence, things of that nature. The other reason why an asset purchase agreement may be preferable for a buyer is the ability to break down tax exposure on the sale, right? Because this goes to Albany in the state of New York, right? They are noticed of this transaction, and there's and the sale price is broken down.
Purchase price allocation, essentially,
Yeah.
so that you can allocate a portion of the purchase price to the specific assets you're purchasing. And each asset class can be taxed differently. Some you can avoid paying taxes, generally speaking.
Like goodwill, which goodwill is just a term for a customer list, right? Any business, a large portion of the value of that business is the customer list, right? I would say
Sure.
40, 50%. I mean, again, it varies on the business, but
More of an intangible, though. You're right about the customer list, but more about like brand reputation and the like. You're not buying. Mike's not referring to a list like a physical list, because this can be considered personal property. But fixtures and equipment, on the contrary, if you're buying, you know, big equipment that's on the site of the business location, or the fixtures and anything like physical, the buyer pays sales tax on that. So to the extent you can minimize the amount of tax that you have to pay in connection with your business purchase, that's obviously better for you, better for your cash flow, better for your bottom line and ROI overall. You can't do that with a stock sale. You're buying the stock, and that's it. There's no purchase price allocation to be made because you're buying one single thing. You're buying the shares of the corporation or membership interest of the LLC.
business acquisition sales in the state of New York are subject to bulk sales requirements. So as I said before, whenever you enter into a PSA or a purchase of a business in the state of New York, the attorneys handling the transaction have to notice Albany, right? They send that PSA and they send an AU 196 form to the Department of Finance up in Albany. And on that form, they break down the transaction, the parties, the consideration, and the Department of Finance then takes that form and they look up to see what tax, if any, is owed by the seller and what tax, if any, would be owed by the buyer on that transaction.
On the purchase, right?
On the purchase, correct. It's super important that this happens, and I can't tell you how many times this is missed by purchasers' attorneys who aren't familiar on handling these types of commercial transactions. And what happens in those scenarios is that the sales tax of the seller can be inherited by the buyer. Yes, on its face. Talk about malpractice central. So it is, it is very, very important, again, both for the attorney that you get that release actually in hand, right?
As a condition to closing.
Well, there's two ways of doing it, right? You can make it a condition to closing, which is the way I like to do it 9 times out of 10. But again, circumstances sometimes don't allow for that. So if there are extenuating circumstances, you could also close with a very, very substantial holdback escrow, where I've even closed with the entire proceeds of the transaction held in escrow because of my fear of a tremendous tax liability. But again, where there's a will, there's a way. You want to be creative in your lawyering. Don't let something like that hold up the deal. You have to be creative in your lawyering.
So outside of the financial and tax considerations that we just discussed, there's also third-party consent rights that need to be kept in mind. Typically, when you're buying a business, or I want to say for the most part, generally when you're buying a business, there's some sort of real estate component, right? Where there's a physical brick and mortar location. May not be on the ground level retail store, could be in any part of a building, but the location that you're going to be operating out of is subject to a commercial lease agreement. And that commercial lease agreement generally does not allow for a sale of a business, whether it's in the form of transferring the rights of the tenant under the lease, or even just an ordinary stock sale. The landlord requires the tenant to go to them first to get their written consent before they can effectuate any kind of stock transfer or assignment of the lease. And it's imperative that you ensure that your seller is going to be able to get that consent from the landlord. To the extent that they don't, you certainly want to make sure that your down payment or good faith deposit is not at risk. If you don't include the appropriate language in the contract to make it a condition to closing that the seller deliver that consent from the landlord, you could very well risk forfeiting your deposit, and that could be tens, if not hundreds of thousands, in some cases millions.
And also, other types of third-party consents that we typically see could come from a municipality. It could come from, again, a franchise, a governing body, specifically again in the pharmacy context. It could come from a local township. So you always have to make sure again that you're doing all your due diligence, and that due diligence can come during the LOI phase, as we said before, or even there could be a carve-out period after your PSA is entered into where you have a free look. It could be 30, 60 days, again, depending on the size and scope of the deal. I once did a transaction where we were representing a fairly large multi-store hospitality group that needed a consent from the MTA, right? They were opening up a restaurant bar in an MTA location. I mean, try getting a consent from the MTA during COVID. It was impossible. I mean, but luckily I had that consent in there, and there was no limitation on it. I actually had a right of cancellation after a date certain. Our clients did want to proceed with the deal because it was a good deal for us, but had I not had that language in there, it would have been an issue for our side. So it's always important to think of all of the different scenarios and how they may, even if there's a 1% chance that they may impact you, it's always that 1% that's going to get you. So, when your attorney is saying, we need to watch out for this, this, and this, and you're thinking, oh, that's never going to happen, trust me, it may happen.
It's our job to think of the scenarios that you as the buyer-seller think are impossible. And no matter how unlikely you may believe for that event to happen, if we don't account for the potential that it will happen, who's the first person you're going to call when your deal dies and you're out tens of thousands of dollars, hundreds of thousands of dollars, if not millions? Pretty sure it's going to be us, right?
Sure.
We're going to be the bad guys. So we're happy to be that when needed, but it's all ultimately for your protection. I feel like I'm a parent talking to my kids. Yeah. We're looking out for you.
Yeah. So the one thing I will note is these deals can become complicated, especially when you start marrying the real estate, the commercial real estate transaction and the commercial transaction, the purchase of the business, together at the same time. You're kind of juggling both sets of facts, two different timelines, two separate, different parties, different wants and needs. So it's important that you work with your attorney and you're responsive, because a lot of things are happening during those times, but you can structure those deals to kind of score both. And it's actually the best time to do so, because you have a motivated landlord at that time to sell to someone who's going to be an owner-operator.
So we often talk about being proactive as opposed to reactive. Say you're looking to buy, you're just starting a new business as opposed to buying one, right? There's a vacant space, you sign a commercial lease agreement, or you're negotiating the lease itself. And after you sign it up and you take possession, you start your business. When you're negotiating that commercial lease, you want to think about, well, where am I going to be in 5 years? I may want to sell a business at some point. And it's for that reason that you need to especially negotiate with the landlord, perhaps a carve out to the restriction on assignment provision, so that you are permitted to assign without consent, or if to the extent the landlord's consent is going to be required, that you require the landlord to not unreasonably withhold, condition, or delay giving their consent. Many landlords typically get greedy and they want to share in the upside, so they say, you know what, tenant, yeah, I'll give you my consent, but I want half of the profit you're going to make on that sale. If you don't make sure, sometimes that is outright said in the lease itself. In other cases, it's not. To the extent it's in the lease and it wasn't brought up in the LOI and term sheet negotiation stage, you want to ensure that completely comes out.
Yeah, a lot of it is market, depending on, again, what the market is doing. Things have changed a lot in the last couple of years. The pendulum has swung, I would say, a bit more towards the tenant side than the landlord side, especially considering where we were just 2-3 years ago. Other things I would also caution or try to get in there when negotiating a new lease upon taking a space is a right of first refusal on a purchase of the property, of the underlying property.
Haven't seen those in a while.
Yeah, you still get them. I just did one the other day. But so it's, again, be creative, and as Socrates said, where there's a will, there's a way, and just always have to think with an open mindset.
Absolutely.
Purchasing a business is one of the biggest, most important decisions you're ever going to make in your professional life. It is important that you have the requisite attorney by your side, or law firm by your side. In terms of what you should look for with respect to hiring a law firm, you want to look for experience, competence, and also responsiveness, but also instead of having a guy for this, a girl for that, and a guy for that, if you can find a law firm that can kind of do everything in-house, and I don't mean one attorney that does everything, because that's a general practitioner, and I don't mean to use that in a derogatory sense, but as the old adage goes, jack of all trades, master of none. But if you can find a law firm that does corporate governance, commercial real estate, corporate transactions, financing, labor and employment defense, compliance, bankruptcy, although I hope you never need it, but don't be scared of bankruptcy, it's actually a tool. Shareholder litigation, what else? Did I miss anything?
Just generally, I mean, at our firm, at least here at KL Legal, we have partners that are extremely experienced in each of these different practice areas, all of which come into play for this one single transaction. I'll negotiate your commercial real estate lease. To the extent, like Michael said, if there's any kind of bankruptcy component, be Ralph Brady. labor law related matters, wage and hour, that's Steven Siegler. The actual corporate business stuff, negotiations itself, Mike Iakovou. Andreas Koutsoutakis, anything and everything restaurant related, he's the guy. But the idea is that whether it's litigation, transactional,
Just general counsel.
it's really about the fact that we have experience sitting at every seat at the closing table, and to the extent that we ever need to go to court, we just need to knock on our next door partner's door, and they're ready to go. So it really is a one-stop shop, and you get everything under the sun as part of that representation. And by doing so, there's no need to utilize different attorneys at different law firms that have no communication with each other. Nothing gets lost in the shuffle, and we really truly cover the A to Z to deliver the best product possible.
We're here for you when you need us, and we look forward to helping you along this journey.